Moving to motion limiting number 10, Hannah's motion limiting number 10. Very simple and it closely resembles this. This one is going to be a motion limiting to exclude testimony that oxidation of the ORP meter in any way affects accuracy. Conditioning affects the stability reading. In other words, how fast does it read? Accuracy is only affected by calibration. That's why in Motley's report, the problem is that these come factory calibrated. That's my point, is that the whole time we've been saying that somehow oxidation can affect accuracy. The reality is it can't. Let's look at the expert on this. His testimony is on page 4. Very short motion. Dr. Babcock, who is an expert and has used ORP meters and knows what they do, including what does conditioning do, what does calibration do, and what does cleaning do.
Why were instructions given pertaining to conditioning?
Good point. So the Kangen water people, when they buy an ORP meter, they want to get a reading as fast as they can. Why? Kangen does not use chemicals. I think I've said that before. There's a machine you put on basically in your countertop of your.
I still don't know what it is, but go ahead.
Kangen is tap water.
Okay.
Okay? It goes into a machine. That machine has tubes, kind of like titanium tubes that we've talked about before. Okay? This has a series of 10 of these tubes. Okay? And they're not made out of titanium. It's Kangen is actually a Japanese word. Okay?
No, I understand.
Okay.
I think they had like a Kangen class cruiser in World War II, something like that. But go ahead.
Yeah.
I think that's true.
They
were actually pretty.
Kangen means lots of. Yeah. As you know, I have a master's in Japanese, so this is.
Is that true or not? What I just said about it? Maybe it's Kangen, but they do have a
class. It's actually Kangun. Gun is for military purposes. So.
Class of cruisers, right?
Yes, Your Honor. And essentially, it could be Kaigun. Kai means sea, or the ocean. SEA. All right. Now that we cut off that tangent for just, and there's no problem.
No, go ahead.
Page 4.
But what do I do about the product literature on conditioning?
Yeah, so the product literature has to do with Kangen, right? And so you asked me the question. That's the question I'm trying to answer for you.
Okay.
Hey, how does this work? Okay, well, what happens with the Kangen people is that the water goes through the tubes. They separate the positive ions from the negative ions. We understand that, right? That water can be charged.
Yes.
Anything can be charged. And it's going to be charged both positively and negatively. When it gets done, it goes through this kind of a maze of different tubes, and there's a little spigot at the end of the machine. You just turn it on, and the water comes down into your cup. Now, there's no chemicals to keep that water remaining just negative, alkaline in that current state. You following me? Because all I have is a cup of negatively charged water. Now, because it's now subjected to the atmosphere, all the free ions of nitrogen and oxygen and whatever else is in our atmosphere, as those things hit the surface of the water itself will change as far as its electrical current. There's a question.
No, I'm listening.
I thought Mr. Kemp was going to ask me something. So the Kangen water comes out. That change from positive to negative can happen very quickly. So they want an ORP meter that will read quickly. Okay? One of the ways to do that is to oxidize the probe. Okay? So oxidation affects the speed, and in fact, Jason Brown, who they keep going to in the product literature and all this stuff, testifies to this. At one point he says accuracy, but later on he says it really only affects how quick it reads. He literally says that in his testimony. They want to skip over that. They don't want the court to know that, but that's what he'll testify when he gets to trial in this case. It only affects that. So what does Jason Babcock do? Jason Babcock on page 4 is asked the questions that you've been asking. Why would you want it to go so fast? Well, because for Kangen water can change so quickly, and we want as negative a water as possible. Is there anything else in the water that's from the tap? No, it's just negative ORP water. That's why they want it to go fast. If you oxidize it, it'll read quicker. That's all it is. Okay, so what does Mr. Brown say? Hanna Instruments expert, this is line 20, page 4, highly experienced chemical and materials engineer testifies as follows. Does conditioning the probe have any other effect besides the stabilizing how fast the probe can get the reading? No. This is in his deposition. Page 20, lines 10 through 16. Does conditioning the probe affect the potential accuracy of negative reading? No. Plaintiff does not offer any expert evidence to refute or rebuke Dr. Babcock's testimony, nor could they because, and note what I said, expert evidence. I didn't say evidence, it said expert evidence. They're going to try to have people up here who are not experts that will say, oh yeah, it does. But they're not experts. So part of the reason why we just went through the motion that we did. The condition of the probe does not affect the potential of accuracy of the MW500. Okay? Then you look at NRS chapter 48.025. You've got to have somebody that knows what they're talking about, that has relevant evidence. Otherwise, we're going to have a bunch of lay people up there saying, oh, sure it does. Sure it does. And Jason Brown will be here, and he'll testify that, no, it has nothing to do with accuracy. It has to do with how quick it is, just like I said on page line this and page line that of my deposition. You're taking what I said out of context, and we'll be on our way.
What's the impact of oxidation on the probe?
Oxidation on the probe has no measurable effect on the probe's lifespan. If that's what you were asking me.
Not on lifespan, but I'm talking about oxidation.
Right, so I tried to answer the question. Maybe it was, I didn't understand it fully. The question, Your Honor?
Well, I mean, apparently, and I want to make sure I use the right term again, but there has to be some form of conditioning, right?
There doesn't have to be. You don't have to condition it at all. But if you do condition it just because you want a quicker reading.
That's where I'm going.
Okay.
Yeah.
Then that's what it does. But it doesn't affect it in any other way. The oxidation, by the way, is only affecting the platinum tip. It doesn't affect the inner workings, the electricity, the electric charge, the gel, any of that stuff in there. It just affects the platinum tip. What's going on is that on that tip, Your Honor, remember it's in that solution when it starts up. Darn it, here I did what I was told myself I was not going to do, but remember the probe I showed you?
Oh, I remember.
Okay, and you haven't seen the tip yet because we haven't taken it out of that solution. That solution isn't just water. Okay, it's got salts in there. It has other things in there. When you take it out, you oxidize it to take off all of those things that could be still stuck on that platinum tip. That's all it's doing. Okay? What we don't want people to do, and that's why we have it in our instructions, don't go in there and manually start messing with it. You might break it. Okay? Don't do that. Oxidize it. Okay? If you want to have a quicker result. That's it. In alkaline water, this is how you do it. That's all. All it does. They've made it into something else than what it's supposed to be. This motion says people are going to try to say that it does something different, and it doesn't. All it does is affect the speed in which it does things, and oxidation cannot do anything more than that chemically. Thank you.
And my last question, what do I do about the product literature?
So the product literature about Kangen water, I can't imagine why we'd have the Kangen water stuff in here to begin with. It's not relevant because it's not the same product. That's very prejudicial. Put in a bunch of, quote, product literature about some other product into a case about real water.
I'm talking about product literature from the manufacturer, your client.
So there is no product literature about real water. There's product literature that they claim is from us, which is actually on someone else's website about Kangen water and using an ORP meter. It's not even our, quote, product literature. It's on websites. You've already talked about, hey, I don't want product literature from websites, it's particularly not your own website that's on there and does this.
What about the conditioning kit literature, preparation and
That
conditioning?
certainly is in there and can be talked about. Yep.
Judge, I can only respond to the motion as drafted. And here is what this motion asks the court to exclude. I'll read the entire thing because it's 4 sentences and 2 words long. Quote, "Hear the testimony that condition," I think it should have been conditioning, "hear the testimony that condition of the probe affects the accuracy should be excluded based on the expert testimony provided by Dr. Babcock."
Right.
Babcock testified that condition, again, I think it should be conditioning, only affect, and I think that should be affects, the time of the reading and does not affect the accuracy of the MW 500 meter. Plaintiff probably should be offers or plaintiffs, one or the other, no expert evidence to refute Dr. Babcock's testimony. Therefore, this court should grant this motion. That's it. That's the entire motion, Your Honor. The word product literature isn't in here. There's no witness identified. I mean, conceptually, it's hard to really understand what they're talking about. And so I think this motion should be denied at the outset for lack of specificity. I mean, motion eliminated shouldn't be guessing games, as we say in our opposition. How do we know who they are targeting this ad, or what product literature they are targeting the ad, or what piece of evidence they are targeted at? And then look at the proposition they're advancing. They're saying that their expert's testimony, his opinion, trumps any other evidence, and so all the other evidence should be excluded. Well, there's a couple problems with that. First of all, his opinion is based upon these tests that got stricken a couple days ago. So they're asking that these stricken tests be the end-all, be-all of this particular case. Okay? But even if that were not the case, you can't say that their expert testimony establishes this point irrevocably to the exclusion of any other potential testimony. And what other potential testimony is there? Chris, can I have it? You've seen this a couple times, Your Honor. I think you'll see it a couple more times. This is the general manager of Milwaukee. Okay. This is Jason Brown, and he says that it's going to take a long time to get the negative reading. Ask him how long, hours to days. He says it will just take longer, but then he says hours to days to get the proper negative reading of Kangen water. And now this argument that Kangen water, which is just alkaline water that had a higher negativity rating, it's alkaline water, Your Honor. It's made a different way, okay, which is probably good because there's no hydrogen in it, but it's alkaline water. This is alkaline water. So what he's saying, and remember the chart Mr. Rasmussen showed you that alkaline rating of Kangen can get up to as high as 800. Usually, I don't want to be a test line expert. Let's just leave it at that. But it takes,
I know it's higher than real water.
It's higher than real water,
Yes.
okay? Because the real water target was 250 to 275. But anyway, it takes hours or days. Hours to days. So, you know, he says, oh, that's time. That's not accuracy. Your Honor, you saw the Blaine Jones video. When you properly condition these probes, whether you do it putting it in vinegar for 5 days or you use the conditioning solution pre-2017, whichever way, if you properly condition the probe, it takes 12 seconds to get the positive reading. It takes 12 seconds to get the negative reading. And we had to stopwatch counting it down. I don't know if you remember motion for some of you guys remember 6. 12 seconds to get the negative reading. So if you oxidize it right, it takes 12 seconds, not hours to days. Okay? I think I would call that an inaccurate reading after 12 seconds, thinking, not knowing. And the real problem here is the product literature. You know, if they had said in the product literature in big bold letters that you could not take negative readings for hours to days unless you oxidize the probe, and here's how to oxidize it, this would be a different case. But they didn't say that, Your Honor. They didn't say that whatsoever. And I think the motion should be denied first for lack of specificity, second because you can't let an expert trump all the other evidence, especially when the foundation for that expert has already been stricken. And third, you know, we're quibbling about words, okay? Mr. Rasmussen calls it accuracy, but I can talk about timing, I guess. You know, it's you know, I'm letting him yell and scream about calibration and oxidation, okay?
Conditioning.
Conditioning, yeah, okay, fine, all right? But I don't think we should just, you know, eviscerate the entire dictionary here on this motion to eliminate. You know, if a witness says, oh, I didn't think it was accurate because I measured it for, you know, 15, 20 seconds and the reading wasn't what I expected, you know, that's just his testimony. They can explore that on cross, what he means by that. But to suggest that we can't even, you know, use the term accurate or argue that it's not accurate because it takes hours to days as opposed to 12 seconds it should take, that is really a far-reaching ask. And it is not an ask that's made in this motion, which I've read to the court. So I think the motion should be denied, Your Honor.
So if you look at this particular document that Chris kindly has left up there for me, look at the second, starting at line 10. Are we talking hours, days, months? See, it's all talking about how much time, right? Not about accuracy, whether or not it read it correctly. It took, how long does it take, right? According to them. Hours to days is what I meant, is what I would say. But with regards to positive ORP, the meter will work fine out of the box, right? Correct. And next question. But negative ORP, it won't? It will read it. Right out of the box. It will read it. Right?
But
it will just take a little longer. What it says, but it will take longer. I said little, I shouldn't have said that word.
right.
It'll take longer. That's all it is. We're talking about, in this whole thing, is how much length of time it takes to oxidize this. Negative, oxidized ORP on the video took 12 seconds. That's what Mr. Kemp just said. How long does it take to oxidize the ORP meter? Not how long it takes to read it.
Here's my question. I mean, the bottom line is this. I mean, I understand what your expert says, but they got product literature. Why wouldn't, are you saying that?
On the Congen stuff, they do. You're right.
But I mean, but nonetheless, for example, and this is a really big deal, and this is why I probably did what I did on the prior one, because I did understand that in a general sense, there's a distinction between a positive ORP read and a negative ORP read, and there's and consequently, you have to do a little extra to get. And I won't say what the term is, but you have to do something extra to get the negative ORP read, right? And that's kind of my point. And so I'm looking at this, and these are the people that, and I don't think, regardless of whether it's Kangen water, and I understand that it has a higher negative
ORP reading.
I get that, it's higher. But nonetheless, the higher you go up, potentially, the slower it takes to get there.
No.
There's conditioning, right?
No.
Isn't that how that works?
No,
Is that
Your
what you
Honor.
just
It's
said?
how long it takes to oxidize. In other words, how long do you leave it in the solutions to oxidize it? The probe.
I understand. I do.
Okay?
But the way they use the product and what they know about the product, and I don't see where Kangen is negative, is a highly negative ORP product. Is that the best way to say it?
Not an ORP product, but
Well, ORP,
alkaline.
alkaline. Okay. Reading. Is that better?
It's just alkaline water.
Okay. Well, a higher alkaline.
Right. Alkalinity.
Level.
Alkalinity or alkaline level.
Okay. Right. I get that. But why wouldn't this all come in regarding that issue? Because it goes to
So the
how
question is, and what we tried to frame this is that what they're doing is mixing it up. How quickly does it read? Note here what he says right there. It's on the thing. But negative ORP, it will read it. Answer, it will read it. He's saying that. Not about whether or not it can't read it. Not about whether or not it's accurate. It will read it. It will take longer.
You brought up accurate.
Well, that's because he doesn't say that. I'm sorry, Your Honor. I meant to say it that way. I think maybe I just didn't say it well on the record. I thought I said that on the record.
Proving my point, Joe.
Anyways, do what you want with this
It's
one.
okay to have a little levity.
You're right, Your Honor. I'm sorry. I'm taking it way too passionate. My mistake.
But I think at the end of I think ultimately, their experience, what they do. I think all this comes in. I just do.
Okay.
So it's their product, right? And I think they're in the best position to share their experiences with the jury.
Okay.
That's what it's saying. So I'm going to deny it.
Thank you, Your Honor.
Don't use accurate again.
Okay. Last one that I've got is motion limiting number 11. We're at 440.
Wait, you have 5 too, right?
Well, we're not going to get done then. I was going to try to get this one done because it's not that long.
I'll submit 5 if you want.
I'm sorry. What, Will, you've. I was trying to get to this, and so I'm not following you right now. And I'm not trying to not
If you
follow.
want to submit 5 on the briefs.
Which 5? The summary judgment?
No, you're 5. Hanna, motion eliminating number 5.
Oh, yeah, we'll submit it on the briefs, Your Honor.
Okay, Your Honor, so we have 1 left, which should be
Okay, go
quick.
ahead and write that down for me, please.
Yeah, famous last words.
So I can go over with Sarah and.
All right, this one's a pretty simple one. In this case, the plaintiffs would like to introduce evidence of chats between Milwaukee and its customers and suggest that Hanna knew about these chats as well. The chats were sent to Milwaukee. They answered things for Milwaukee's customers. They were not given to Hanna. We don't have knowledge of them. We didn't use them. Having said that, does Carl Salvaggio do things? Yes, but not until after the super bad batch is made and created and done. So should chats that are post-date this, that Carl is answering as president of Milwaukee, be something that should be evidence against Hanna? No. That's the...
No, go ahead. I'm listening.
Okay, I'm sorry.
I don't want you to slow down.
Okay, there are chats that customers are having with Milwaukee. Milwaukee and Hanna are 2 separate companies. Okay? What we're trying to do is exclude that this evidence of chats can be used against Hanna.
And I have a question. Didn't we have a manager or officer that had dual capacity in both?
Yes, and I just identified him. Carl Salvaggio, just said his name.
Right.
Okay. He only starts to look at chats after this case has been filed. Just, you know what I'm saying, Your Honor? So its relevancy is what they were talking about at the time this was done. Until that time, Jason Brown did it. Jason Brown is not an employee of Hanna. Carl Salvaggio never looked at any chats about ORP meters or anything else prior to the filing of this lawsuit or prior to Belsky, Haley, and the other 5 plaintiffs in this case. So what I'm trying to prevent is say, oh, look, Hanna knew about this. Okay? That's all. And it shouldn't be counted against me if I don't know anything about it. Thank you.
Your Honor, I'll take this one and try to be brief. 2 things. Carl Salvaggio is the president of Milwaukee Instruments, and he's the vice president of Hanna. So there's 2 things. One, Hanna has knowledge of this through Salvaggio, regardless of whether Salvaggio participated in the chats or not. He's the president of Milwaukee that's engaging with these customers in chats. He's the vice president at the same time with Hanna. And you can't say, well, oh, he knows it as the president of Milwaukee, but he doesn't know it as the vice president of Hanna. He's an executive officer, a high executive of both companies. So what he knows from one company, he knows in his capacity as a related entity, a sister company. That's number one. So that alone warrants denying this motion to suggest that you can, disclaim knowledge when you're the executive of both companies is I think, grounds alone. But on top of that, Carl Salvaggio actually participated in answering these questions. As we cite in our opposition and attached, I mean, he himself is engaging with these customers. It's him answering these questions. And the argument there is, well, that's not until after the super bad batch in 2020. Well, I think Mr. Rasmussen, whether intentionally or unintentionally, has misstated a lot of what the actual evidence is in this case, or has stated things without regard to what the actual evidence is. In this case, there's no evidence to suggest that any of these chats are after the super bad batch in October of 2020. Chris, can you pull up the opposition for the Milwaukee motion? This is from our opposition to Milwaukee's similar motion trying to exclude these chats that was submitted on the briefs. And the argument there was, well, page 3. And the argument was there, they came out for the first time and said, oh, well, we didn't even know we could preserve these chats until 2023. Well, first they produced them in September 2022. So there's something going on with what they're saying on the dates of these chats. The chats themselves are not dated at any time. And so we asked Jason Brown in his deposition about this. We asked him point blank, and is there any way you can tell what year or month these pertain to, referring to the chat messages? Answer, no. I can tell you that the e-commerce messaging was up and going, and I would say fourth quarter of 2019, and it started out kind of slow. It really picked up in 2020 during the pandemic. So prior to the fourth quarter of 2019, there was no type messaging, correct? These messages have to be from the fourth quarter of 2019 to the present, right? Yes, correct. That's the testimony in terms of the timing of this chat from Jason Brown. That's the evidence. So the suggestion that all of these chats are after the super bad batch in October of 2020 is completely refuted by the actual evidence and should not just be accepted carte blanche, especially when they're making statements that these chats weren't even preserved until 2023 when they were first produced in 2022. I would note as well, several of the chats, they refer to earlier dates than what is represented. I think there's one we cite in the motion. If you can go down in the opposition, if you can go down, Chris. Go down a little. Oh yeah. Well, the one cited it's referring to the order in October 2020, and there's other ones that reference earlier time periods where they're saying I had a problem or I bought it on this date that go back to 2019. So the idea that these chats all post-date the bad batch is wrong and contrary to the evidence. And regardless, as president and vice president of both entities, I mean, how can you disclaim that Hanna has no knowledge of the operations of its vice president of operations? So for those reasons, we ask that this motion be denied.
Carl Salvaggio testified and that he did not have anything to do with the chats in 2019 or 2020. That batch was made in 2020. So he has no knowledge of these chats. He's the only link. If Jason Brown knew about them, then he would have to have told Carl about these. Carl Salvaggio says, I did not receive anything from Jason Brown with regard to these chats. Therefore, all I'm trying to seek is that these chats can't be used against Hanna. However, I think that the court should say, let's wait until the evidence comes in, see what they say under oath at trial, and I'm happy to do that and have this motion denied until we get there, because I know it's going to be the testimony.
These are all interlocutory in nature anyway.
Right. That's why I'm saying we're fine. But now the court knows the issue. And more than anything, when we get up here, well, didn't you get this chat? Nope, I didn't, because I wasn't involved in that, and we'll have that to go forward. The authenticity, just so you know, will also be an issue as to who is sending these chats. Are these customers? We think most of them are plants. They're not even chats starting in 2022 that have anything to do with someone that actually has an ORP meter. We think they're just trying to create evidence. But we'll deal with it down the road.
Plants by who?
I don't know who, Will.
Your Honor,
Yes.
this is Elizabeth Lowell. I apologize for not having appeared before. I am monitoring these hearings for Milwaukee, and I just wanted to make a brief statement that I was the one who did productions in September of 2022. I do not believe there were any chats produced at that time. I will go back and look and tell Rob Robbins to correct the record if I'm wrong, but I don't think they were produced until January or February. It must have been January. And that's all.
23.
Okay. And thank you, ma'am. I appreciate that.
That's all I had, Your Honor. Thank you.
Okay.
Your Honor, if I can show one of the chats on this, for the record, to one of these supposed planted chats that were produced by Milwaukee. Can you exhibit it to our office?
We'll step down and just go over the rest as far as board was. And it can pass that along. Yes, sir.
Court's indulgence, we're pulling it up. Pull that top one up.
What's the date?
No, the chat.
What's the date?
These chats are undated, but
Okay.
to suggest that they have nothing to do with the meter at issue, I just refer the court to the top chat. Hi, Carl. I'm inquiring about the negative ORP readings. You have referred me back to the literature, which only states to store in vinegar with less than 2.5 pH, which has been done according to the literature. If I'm not receiving negative readings, how do I determine if the new probe is working properly? Carl, meaning Carl Salvaggio, the president of Milwaukee, the vice president of Hanna, responds, in the manual it states, if needed, clean the platinum tip with very fine abrasive paper. This can be a 220 grit or finer piece of sandpaper used to gently rub the platinum tip and retest. He's answering these. This is directly related to issues with the negative ORP readings with the oxidation in accordance with the literature. It's not working. It's notice of a defective condition. Doesn't matter if it's before 2020, after 2020. It's irrelevant to the defective condition of the warnings and the instructions. This is knowledge to both Milwaukee and Hanna as, again, Carl Salvaggio is the president of one company, the vice president of the other.
So the only problem with this is that I don't even have a date to lay the foundation of when this happened, who this is. Otherwise, it's just a speculative document that we don't know anything about. It was produced by Milwaukee, but we don't have dates on this. How am I supposed to know if this is relevant to the time period and possible? I don't see that.
But
What if this was done in 1936? Do we know that?
what if it
Of course
was
we
done
don't.
in 2019?
Well, we know that Carl wasn't involved in that because I've just told you that he didn't do anything in 2019 or 2020. So this is probably 2022.
But I mean, we don't know that. And, I mean,
We don't know. Yeah, and so it's speculative.
No, we know this was a business record of whom?
Milwaukee.
Right.
And I'm saying this can't be put on Hanna.
And he's the president of Milwaukee and vice president of.
Well, they claim vice president. He's actually the chief operating officer. But yes, he's a manager. But I mean, just to make the record straight. That's all I'm saying. I don't want to cause you to cough, Your Honor.
No, I just kind of chuckled a little bit. He's the operating officer.
Yes, he is. I'm not getting away from that. But to suggest that in 2019, this is something that he's aware of, we don't have any authenticity of this. How do we know that's authentic as far as the time? Well, there's no foundation as to the date. I'm using the wrong word.
Yeah, well, we know it's authentic because it was produced by Milwaukee, right?
What we don't know is when. What time period is this? If it's 2022, is it relevant?
Well, I would think, and I'm not 100% sure on this, but I would think that if there was an issue regarding the date, because I would hope that when it comes to chats, text messages, and emails, they have dates.
Yeah.
And so potentially, this could be 2019, it could be 20, 21, 22, because I would anticipate a business would keep dates of chats with consumers. What I'm going to do, I'm going to deny the motion. I mean, it is what it is, and it's going to come in. It is a business record, and we'll find out.
Okey-doke. Thank you, Your Honor. Those are all of my motions. I don't know what else needs to be done.
There's a couple of things we need to do
Thank you, Your Honor.
before we leave. I do have one letter that was sent to, was this to Jury Services? Yeah, it's dated August 31st, 2023, 225, and I guess it's to Lynn from Jury Services. I apologize. And it provides the following. Panel member called in, and she said her date now to call is 9/7. She said on this date she will not have a babysitter. She said she would not have had one on 9/5 either. Her baby is 5 months old. She now has been diagnosed with prediabetes and has a doctor's appointment on 9/14. What do you want to do about her?
What badge number is that, Your Honor?
This would be badge number, let's have it here. How about 3854? That's probably Japanese. You might know that.
Want to spell it? I'll tell you. Yes, it is. That's Japanese.
That's what I thought.
Honor, I think someone that might have some expertise on Kangen water might be very helpful.
The name Kangen, I do, because you guys keep saying it the wrong way. And my last name is Rasmussen, not Rasmussen, but it's okay.
Do we have an agreement as far as she's concerned?
Yes, Your Honor.
Yes,
Yes, Your
sounds
Honor.
good.
We excuse me.
So, well, excuse her. And we have one more. And this is from Nuclear Care Partners. And it's a very similar letter and a slightly different scenario. We are the employer. Your number, ID 106468190, was received a summons to report to Clark County on September 5th. Mr. Jordan is employed with us at Nuclear Care Partners, a home health care company that serves former atomic workers. He is the Nevada branch administrator and oversees our Nevada location. Our company has recently experienced a leadership change in the Nevada branch. As a result of the change, the two assistant leaders are undergoing training in a different state and will not be available for the required time in September. Mr. Jordan's absence will create a hardship for the company, et cetera, et cetera. I know nothing about Nuclear Care Partners. They're out of Grand Junction. And this isn't his hardship. This is the company's hardship. You can take a look if you want to.
Do you have a badge number, Your Honor?
He has an ID number, 106-468-190.
Judge, I don't have strong feelings either way, but I would note that company hardships are not recognized as.
I agree on that. And they go on and say here, there's no other employee in the company who can fill in for him, as he is the one who leads and manages the entire Nevada branch. Anybody know anything about Nevada? No, Nuclear Care Partners. Home health company that serves former atomic workers. Could this be test site workers that potentially, I mean, that's the only thing you can think of.
Yeah, it's probably guys that worked out there at Mercury and they've got some issues and
Judge, whatever the defense wants to do, we're fine with on this one.
Appears to be a home care provider for atomic workers across the U.S. We have no problem. Real Water has no problem excusing them.
I won't be the one keeping him here, Your Honor, but
me neither.
I'm sure there's not an employer who's thrilled about any of its employees
Yeah.
being gone for 6 or 7 weeks.
All I can say is this, and I don't mind saying it. Nuclear Care Partners, I don't know much about it, but if they're taking care of some of the former atomic workers at the test site and stuff like that, I can see where we might defer and let them go. And if everyone agrees, I'll agree too. That's slightly different, but many times, I should say, I have hardships being claimed on behalf of the employer, and I don't accept those. I just don't. But anyway, so we're taking care of that. We're going to let both of them go. And next, we want to go over the list to make sure we know what's under advisement, right, Tori?
Yeah, Judge, I made a list.
Okay, and as long as you make sure Tori gets it, we're fine.
I have one quick question before. Mr. Rasmussen, you said that your motions are all done, but I still have your motion for partial summary judgment. Using direct evidence on strict product liability claims.
Submit on the record. Submit up for the court to decide that.
Wait, put that on. Yeah, we can. And we're going through the list now, and Tori, when you're ready, you can start.
Your Honor, this is Eddie Parker. Can you hear me?
Yes, sir.
Good afternoon, Your Honor. I believe Mr. Neale and I come to an agreement on Plaintiffs' motion limit number 43. And Mr. Neale's there, so I'm sure he can correct me. I invite him to correct me if I make a mistake here. But I believe what we've decided is that we will redact the medical record related to Mr. Haley's or Plaintiff Haley's marijuana use. Was plaintiff's motion preclude that evidence, Your Honor, or remove it from or redact it from the medical records, since no one is of the position that his occasional marijuana use caused his acute liver injury.
And while that's correct, Your Honor, there is a symptom to which the physicians attributed the marijuana use. It's leukopenia. As long as we don't kick that door wide open and start talking about how bad the leukopenia is, we agree with Mr. Parker to redact the marijuana use from the medical records.
All right.
That's all I have, Your Honor. Thank you so much.
And you can put in, how do you spell leukopenia?
LUEKOPENIA.
No, would be
From now on.
subject to open out the door. You got it right, sir, I think, as far as the minutes are concerned.
Judge, under advisement. We're ready. Motion for summary judgment number 1 by plaintiff, Chris Rand, is under advisement.
Yes.
There was a motion for reconsideration on the motion for summary judgment number 5 that is now moot. That would be Mr. Parker's motion for reconsideration is moot.
I have plaintiff's motion for summary judgment number 4 as under advisement.
Yes.
No, I think there was a minute order issued on that one. that was denied, but now moot anyways.
Yeah, I thought that was denied too.
Will, on number 5, was that limited to real water? Because it was capped.
Yeah. Well, I think we're just withdrawing the motion for consideration as to everybody.
You're withdrawing it.
Right.
Okay.
So that number 5 is withdrawn?
The motion for summary judgment was already denied, so we're
Agree.
withdrawing the motion. Okay.
Wait, make sure Victoria understands, because she'll have my list, and I want to make sure I don't miss anything.
We
So,
filed a motion
plaintiffs-
for summary judgment number 5. The court denied it.
Correct.
Then he filed a motion for reconsideration, but now we're withdrawing.
Withdrawing the motion for reconsideration.
Correct.
Correct. I got it.
All right.
Sorry,
Well, that's no longer pending.
I just have to search for it and get it off the list.
Then I think I go all the way to. Which one was it? Okay. I think my next one's unit. Okay. Plaintiffs' motion to eliminate number 13. To preclude UNFW from arguing and inferring their violations of law. The regulations are relevant.
The next UA that I have is UNFW's motion limiting number 2.
Okay.
UNFW number 2.
I thought that was granted as to immigration status
Yeah, that was granted.
and denied as to criminal history.
Right.
And denied as to what?
Criminal history.
And a minute order issued on that one.
And the next UA I have is UNFW's motion limiting number 19.
UNFW number 2.
I have that as denied.
Sadly, I do as well.
And going back to the criminal history, I just want to make sure the minute order was correct. What was that issue? Tell me.
Prisoners, Your Honor.
The halfway house
Okay,
prisoners.
no, I understand. So we're not talking about convictions of a crime?
No.
Okay.
Well,
I think we are.
We are.
No, we're not, here's my point. We're not talking about, for example, you have a party who committed a crime
We're not talking about that.
and a conviction. I understand. I'm with you.
Next is plaintiff's motion limiting number 13.
Okay.
That's under advisement.
UNFW's motion for partial summary judgment on plaintiff's claim for punitive damages.
Correct.
Yeah, that's under advisement as well. Excuse me.
I believe that's all of them.
I have a couple more here.
Yeah.
I have, Real Water's motion eliminating number 9 on the media. Was supposed to be submitted on the briefing. Now I have that as moot.
Well, I don't know that it's moot.
Rapidity Lifestyles motion limiting number 9.
Right.
Yeah, docket 368.
I don't care if it's moot or not. It was, I
I mean,
thought it was moot.
Even with the admission, we don't want the hearsay newspaper articles coming in.
Well, I mean, no one's.
There's a lot of newspaper articles are.
Okay, well, that's submitted on the briefs then.
Which one is submitted on the briefs, so I know?
That's
Okay.
Rapidity Lifestyles motion.
Correct.
368.
Okay, then I have 4 Milwaukee motions in a row that have been submitted on the briefs. Milwaukee's MSJ on causation and superseding cause. Milwaukee number 1 on computer chats, Milwaukee number 2 on accurate negative readings from the Ort meter, and number 21 on Dr. Hull. So those 4 I have as submitted on the briefs. Okay. All right. And I have 27, the jury instructions. We're still supposed to do a meet and confer on that. Okay. Then I have plaintiff's motion number 35 on unrelated medical conditions for Mrs. Ryerson, and I have that being submitted on the briefs. And 36 was granted. Okay. We did not argue this one, did we?
No.
Yeah, I have plaintiff's motion limiting number 838 that still hasn't been argued. That's the last one I think we need to argue.
What was the number of that one?
That's 38 to
Thank you.
preclude testimony and arguments regarding a purported lack of liver injuries, etc. But the history motion.
I don't have a ruling for plaintiff's motion number 41.
41, I have that as moot.
Yeah,
So does that mean withdrawn?
that was the Real Water Tennessee thing.
Yeah, that was the real war in Tennessee, which became moot when they got.
Moot, so it's okay.
What's your next one?
After that, I have. We discussed plaintiff's motion limiting number 24.
Yeah, I think that's moot because that went to Dr. Alsina, who was Real Water's expert.
Yeah, it's part of a deal Teddy and I are working out.
Okay, so you're still working on that?
Yeah.
Okay.
Should I mark it as moot or?
No, I think you
We'll
should
arrive at
say pending deal.
We'll arrive at a resolution.
And put in parentheticals pending resolution of the parties. How's that? Close.
And I think there was another motion tied into that one, too.
There is, it's Real Water, or it's Real Water motion limiting number, let's see, 10 to 10-6. Yeah.
Real water motion eliminate number 3
Yeah, that's it, thanks.
to preclude statements, arguments regarding future medical care and treatment,
And that's tied with plaintiff's number
Yeah.
24.
as is plaintiff's mill number 20 to preclude Dr. Alsina's opinions for failure to timely produce at deposition. So those 3 are to be subject to a stipulation by the parties.
And we're missing the one from UNFW with Tom Pham. I was looking for that number. The court was going to rule on that.
There's motion limiting number 20 that still needs
The last 2 I had are Hanna number 5, we're doing on the briefs, in regards to Dr. Motley. And then Hanna, motion for summary judgment, lack of evidence on strict product liability claims, we're doing on the briefs.
That's correct, because there's 2 different claims from the ones born and the other ones we don't know.
And let's go over those again so Tori can get them.
So there's a motion for strict product liability.
Let's go to the motion. You know, is that it?
Hanna's, yeah. Motion for partial summary judgment.
Do we know what the number is for that?
That's 548.
548.
That's on the briefs. And then the one motion eliminated regarding Dr. Motley is also on the briefs.
Number 5.
And that's 492.
Thank you.
Those are submitted on the briefs. Okay.
That's it, Your Honor.
I think there was one portion of motion 305, it's UNFW's motion to eliminate number 14. I think we were waiting for the court's ruling on Mr. Pham's
That's right.
Yeah,
testimony.
that's the one we just talked about. Right.
Denied permit.
It was denied, I thought, with exception of
Denied,
that one.
except the court was looking at Mr. Pham's deposition, Your Honor.
Write that down.
That is UNFI number 14.
I still don't have a ruling for UNFW's motion in limine number 20.
And that one deals with punitive damages. We, I think, agreed not to take it up until we had to. We're content kicking that can down
How
the
about
road.
that one there? Then we'll just say not ripe for adjudication.
I think it should be denied because it's the same as Hanna 3 and 4. It's the same issue nationwide.
Okay, well, here's my question. If there's not an agreement to wait later. I mean, I've heard so much argument that we can with everybody. I can't remember the particulars of each one. I just can't.
The court's ruling, as I understood it on those, was bring it up later
Yeah.
if you need to. I don't know if there's a difference between denied without prejudice or not right, but it
And that
makes
was
sense.
that was a motion to eliminate, right?
Number 20.
Yes, sir.
Interlocutory anyway.
So,
So,
So even if I granted it, that isn't necessary. You see where I'm going. You've been around the block many times, sir. I know that.
yes, you do.
I'll just take a look at it. Just put it on the list and
For UN. And then I also don't have a ruling for plaintiff's motion to strike defendant Milwaukee Instruments answer for violating special master's order.
Yeah, we never heard
Failing
that.
to produce documents.
Yeah, Mr. Parker is going to talk to Mr. Robbins about that and see if we can work something out.
And
wait, and just put next so we'll know. Like the other subject of resolution by the parties. Might not be right then. Something.
that's everything.
Did you want to see us again before Wednesday at jury at 1 o'clock with regard to any of these issues? Really just asking what the court.
No, I mean, is there a need for a status check before then?
I think it never hurts, Your Honor. I mean, we've got Tuesday.
So what is it, Tuesday?
Well, it'll be Tuesday afternoon.
Tuesday afternoon,
They're already on schedule.
1:30. That's when the jury's coming.
Well, that's when it was originally set to go.
Oh, okay, so I mean, it's set to go, so we have that afternoon, say 1:30?
That was fine, because we do have one UNFI motion left to argue.
We can argue that one then, I guess.
Yeah, okay. That's fine.
And which one is that left to argue, so I can?
That is
number 38, Your Honor, legal history.
plaintiffs.
Plaintiff's motion number 38.
And that'll be calendared for 1:30.
Yes. And just so everyone knows, anything that is pending stipulation or is being submitted on the briefs is remaining on calendar, just so the court doesn't miss out of it.
Thank you.
That's like a tickler for us.
Yes.
Is that it?
I think that's it.
Right.
Your Honor, I'd like to thank you for the time and effort you put through this argument process. I'm sure counsel echoes that.
Actual staff as well.
Your staff.
Staff has done a wonderful job.
Concur. Thank you.
So I guess I'll see you Tuesday at 1:30.
Yep.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.